Okay, so I'm going to open the November 16th, 2020 Policy Committee meeting. Okay, Julie's here. We have, just to remind everybody, we've gone to a 3-hour format to try to work through as much of the long queue of policies in the works as we can. So I'm going to try to remember to take breaks. If I fail in that attempt, I'm going to trust that people will make their views known. Okay.
Director Moore, can we have a break now, please?
No. You can make your views known. It doesn't mean I'm going to say yes, but just saying. But let's try. I mean, we have, if we stay on schedule, we can probably make reasonable breaks after about an hour. So let's try to do that as much as we can. If it goes too much beyond that, then we might have to interrupt the discussion. Okay, so before we get on to the full agenda, which is pretty full, I wanted to pick up on something that we talked about at the last meeting. I don't think I've had a chance to talk to everybody about this, so forgive me. But I want to go over the idea that we talked about last meeting of having board members of the committee work with staff on language so that we can take a lot of the copy editing work outside of the meeting time, so that these committee meetings can be more focused on kind of concepts and giving direction to staff. And a lot of the discussions about Oxford commas and such don't have to happen on camera. Which I think will make it easier for onlookers to actually follow what we're doing. And I hope will make it a bit more efficient in terms of everybody's time commitment. So, so looking at what we have in the queue over the next few months, I have a proposal for kind of matching board member to specific policies. So I want to talk about that and hopefully get agreements around that, and then we'll move on to the rest of the meeting. So we have a number of policies, and in no particular order. I would like to suggest the following pairings, and let me see if I can get the whole list out. Please take notes as I go through this list, and then if anybody has any issues, then we can talk about it. So the complaint policy, yeah?
Do you think you could, just so, since we have it, is it laid out on the work plan that we can marry it, or do you just want us just to quickly write notes, or either that or speak slowly?
Well, I mean, all of the policies that I'm talking about are listed on the work plan. So I'll try to take them in order. Okay, at the top, real estate policy. I would suggest me and Ailey. The second one on the list, all students belong, which we are, I think, renaming, and you should have a draft, an initial draft. But for that policy, actually, I don't think we have anybody. We're going to take bids on that one.
I'll take it. anybody else who wants to work on it.
Okay.
That Julia was we had kind of talked about having a resolution on this, and Julia was the only one who reached out to me from our board colleagues interested in shepherding that resolution. So I think she's definitely one of the ones who should be on there.
Okay. And we'll be talking about it today. Okay, next.
I'm glad to provide any support, Julia, if you want somebody to bounce ideas off of.
Great, thanks, Scott.
Okay. The comprehensive sexuality education. I don't think we, anybody interested in that?
I want that.
Okay. Okay. Student suicide prevention. I would suggest Scott. Title IX. So the original thought on the Title IX policy was that we were going to postpone discussion of that. So, I don't have a recommendation on who should work on that one. But I just heard today that we should probably go forward with that policy. The idea for the postponement was that in light of the election results, it is likely that there are going to be some revisions at the federal level, but given that any changes at the federal level will probably take a good long time to wend their way through the bureaucracy, it's probably advisable for us to go ahead and try to tackle that policy sooner, with the understanding that we may end up having a revisit at a later date.
I'm happy to work on that, especially if we don't have to work on it.
Well, there are still some state statutes that are requiring changes as well. So, but
yeah,
and yes.
So we are going to have to work on it. The question is how much. Okay. Anybody else interested in working on that one?
So I'm waiting to hear the whole list before I can
Okay.
circle around and again provide some teamwork on some of these.
Okay. Proposed new policy on indemnification. I'm suggesting Julia and I. The complaint policy, I would suggest Julia and Scott. Professional conduct, I would suggest Julia. Climate crisis response, Scott and I. Code of ethics, Ailey and I. I just want to make sure I've got. I think, okay, so I think that covers the list for the policies that are either currently in the works or about to be discussed. Okay, so that's the list. There will be more coming as we move on. But does that sound okay to people?
So I'm happy to help out with sex ed and with Title IX, since maybe Julie and I can do nothing together. It was a joke.
Okay.
You made me relook at my list. I was like, what?
Okay, so Scott, I appreciate your enthusiasm, but I want you to think about whether, I mean, that would give you 1, 2, 3, 4, 5. That would give you 6 policies. That's a lot. So
This is Ailey. I only have 3. So I'm thinking about maybe either Title IX or doing professional conduct with Julia. I'm happy
I
to
would
those.
suggest that Title IX and professional conduct be the same people because some of the Title IX changes are in the professional conduct policy. So those are linked, if that's helpful.
All right, Julia, you want to be a team on those?
Yeah, as long as Scott's okay letting...
Yep, totally.
Okay.
Okay.
Yeah, that'd be great.
Okay, add me to the sex ed though, and I'll help out with that.
Yeah, and it looks like we still need one more person to work on the suicide policy with Scott. Are my notes?
Yeah,
I
yeah,
think
I think the thought there, so I'm going to say something, Liz, and then you correct me. I think the thought there is that it's likely that there won't be an enormous amount of work attached to that policy. So, so we were thinking that one board member would probably be enough, and that adding a second one might actually complicate life. So,
Okay.
Rita,
okay. Yeah.
how do you feel about the student representatives being on this, that being Jillian and Jackson?
I was going to ask the same thing if our student reps wanted to join in on any of these.
So I would, so I had the same question actually, and we had not talked about that at the last meeting. So I think it would be, good on a couple of levels. I think it would be a great experience for students to really walk through the nuts and bolts of, you know, making the sausage. At the same time, I want the students to understand that this could end up being a fairly significant amount of time. So it could be a fairly big time commitment. But that being said, I would say, given that we've got a lot of these and there are 2 official student reps to this committee, I don't think they should be assigned to all of these. Mm-hmm. So here's my suggestion. I'm going to be sending this list out, and I would ask the student reps to indicate if they're interested in participating in any of these, and if so, which one.
Okay. Yeah, absolutely. And I'm happy to as well. I'm no longer an official representative. I think someone wanted it limited to 2, which is a discussion that can be had at a later date. However, if the student representatives or you, Rita, would like another student to help with the policy, I'm happy to as well.
Okay. So how about we take this offline, and I'll talk to the student reps, and they'll pick and choose, and then we'll broadcast the meeting. Okay?
All right. Thanks, Rita.
And Jillian just mentioned she's interested in suicide prevention. Okay. Okay. All right. Any questions about that? The exact mechanics of how this board staff off-camera work is going to happen, we still have to work out some details, but I'm hoping it will make the committee time more efficient and effective. So, okay. All right. Moving on. So the first agenda item is the formal complaint policy. Okay, so before we start talking about the red line version, I want to note that you got a second document last week. And this is, so this, the origin of the second document is I've had some conversations with staff and the superintendent. And there were a number of comments around how we're framing the topic of complaint. Because right now the complaint policy focuses almost exclusively on the formal complaint process. But I think there is some appetite to kind of reframe the policy to indicate that the formal complaint process is really intended to be kind of the last resort, which really comes into play only if all other mechanisms within the district to resolve issues have been have failed to provide a satisfactory outcome for the complainant. So I asked Liz and her folks to draft some language, and it's very much a draft, that would put this formal complaint process in a bigger context. And there are some things happening within PPS, even as we speak, that may, and I hope will eventually, kind of streamline the process for families about resolving issues that emerge. Some of the things that are happening are in the very early stages, so it's probably inadvisable to make explicit reference to them right now. But I do think there's some value in adding some new language as kind of an extended preamble that talks about how to resolve. So that's kind of the point behind this new language.
So Rita, does it make sense to at least have the board members who are members of the committee to have a better sense of what those things are, so that we can think about how they fit with the policy?
Yeah, I think so. So I'm aware of a lot of what's going on. I'm not sure I'm totally aware of everything, and I'm almost certain I'm not entirely aware of the status of these things. Liz, would you feel comfortable kind of talking about some of the things that are in the works?
Sure, and I'd love Stephanie and anyone else on staff to dive in, because I think it's a collection of conversations and work strands. And in fact, it may be responsible for me even to hand it over to Stephanie, but I'm trying not to just do that unannounced. There's a new position. I think one of the big pieces is that the ombudsman position was eliminated a little more than a year ago. And now that there is going to be a new position, the title of which is something like Family Resource Coordinator, that will likely sit in Jonathan's team, was the last version I heard in community engagement, but maybe Stephanie can chime in if there's been something since then. But the idea is to
Can I don't think this is the venue to really talk about the details of the position. I do think it's worth, I mean, for our purposes, in terms of the policy, I think it's fair to say that there will be a position. We're not entirely sure about all the details, but there is going to be some kind of position that would provide system navigation and resource coordination and kind of being the first stop for families who are having some issues with somebody about something. So I think it's worth, even if we can't fully define it right now, for the purposes of drafting some language, I think we probably know enough about kind of the broad outlines of the position to build in some language. And there's at least one other thing that is in very, very early stage that would allow give the district capacity to more efficiently and effectively track emails and other messages that come in indicating that a family or a student has a question or a concern or an issue. It's probably too early to mention anything specifically in the policy about that, but that I mention it just to indicate that there are some system improvement things going on in the background, which I think make it even more compelling to have some kind of initial preamble in this policy that talks about the the complaint response system more broadly. Anyway, does that help, Julia?
Yeah, thank you.
Okay. Okay, so we have some language in front of us, and I'm going to suggest that we not go line by line in this. I wanted to sort of broach this during this meeting, but I think this is one of the places where we can more efficiently do this outside the context of the meeting, because even if we like the language as it currently sits, there's some redundancies with some of the existing language, and we can probably blend it better. But I think that counts as copy editing, which we're trying to avoid. So I just want to, if you've had a chance to look at it, does anybody have any issues with the concept or the kind of the general direction that this language is going?
Concept looks great. Who's gonna, what are we gonna do with refining this, or how's that gonna work?
So I think, no, go ahead. Please go ahead.
I was just going to say, this is translating multiple conversations and points of view into a first cut. And if there is general agreement with this direction, we can take conceptual feedback in the meeting, or more refined copy edits by email, then consolidate into a more full-flowing draft. It was so conceptual when presented originally to us to draft something that we left the existing language there, so there was an ability for board members to see what was there and what was changing as an alternative approach, more than just some of the editing we usually do. So I would say if we have a conceptual conversation here, we will and take any other smaller, more word choice, wordsmithing edits in a red line, we can come back with another draft next meeting.
So Julie and I are the subcommittee on this. So
we would talk to you beforehand. Sorry, I was thinking of the full committee process.
Yeah. I'm trying to figure out how this is going to roll.
I think we will. Let me just go back to that issue more broadly. Now that the board members have been assigned to specific policies, we'll set up time to talk through on a per policy basis what the next steps are. I think there's not necessarily a one size fits all model. Some policies need a lot of work, some needs a lot. You may have a different assessment of that than I do, so we will touch base on individual policies as assigned and work out next steps and the right cadence.
And I think we're all going to have to, I mean, this is a new way of doing this work, so we're all going to have to sort of figure it out as we go along. Okay, so any other commentary about kind of the direction of a new preamble?
So I think it's a great start, and I think it's way more welcoming to families. I have some like smaller language changes, but I think the one thing that I like that's a kind of a larger conceptual idea, instead of calling it a preamble, which is sort of like, I think a lot of times people are like, I can just go, now let me get to the meat and just skip through it, is like if we actually want people to think that this is like where we want people to start, I think we should like make it a formal step, not step in the sense of Division 22, but for people to feel like, okay, I've got an issue that I haven't been able to resolve, like here's what I do, versus that's the preamble. I'm going to go right down to they're telling me to file, I've got to file a complaint. And so I would just make it sound more official in some way without it being the formal process. And super encouraging people to do it like we think, and maybe adding more like exciting general language of like, we think this is how people get actually the most satisfactory responses versus going through this other process. Not saying you can't use this other process, but really encouraging people like this is the place where it's closest to the work that you can get actually more satisfactory responses.
And maybe even call this a conflict resolution policy as opposed to a complaint policy, which I think captures what we're not going to call it a preamble anymore, but
right.
I'm sorry.
I really like that, Scott, because I think if people are looking, oh, so what I do is I file a complaint, right? But if we're saying, I think calling it a conflict resolution policy says we as the district want to partner with you to resolve problems and bring restoration, rather than it's all about this formal process where you complain and then we sit on high and decide. But that it's about trying to resolve and improve. I like that conflict, and I don't know, conflict resolution, I don't know if that's the right language necessarily, but I like resolution policy doesn't quite work, but something like that is good.
I agree. I think we are talking about it. I mean, in real terms, we're talking about conflict resolution, but I think the idea or the ideal might be to give people a kind of guidelines on how to deal with issues before they evolve into actual conflict. It's like questions, concerns, issues, so we're going to have to get a little creative in the wordsmithing, I think.
Kumbaya policy, is that what you're suggesting?
What is it? What?
The Kumbaya policy.
I mean, I think you do have to have the word complaint in it, because also we don't want it to be like you have to go. People have to be able to find it, and I mean, the reality is some people are going to be like, I've already done that, and now I'm want to file a complaint. So I think it should be an and.
I want to consult Division 22. We may have to have it formally say complaint somewhere in it because of that required process, but we'll do our best to expand and modify to convey what I think we've heard, and we'll find out if it has to state that or not, or whether we want it to anyway, but we'll come back and let you know if there's a regulatory requirement for it.
Okay. Any other comments? Liz, did you get enough to work with?
I did. Thank you all.
Okay. Okay, so let's then kind of pick up where we left off at the last meeting. And again, we're going to try to avoid wordsmithing. We're going for, concepts. So if my notes are correct, I think we left off last time at page 4, which is Roman numeral 4, filing an appeal, step 3. So B, step 3, appeal to the school board. Is that accurate? Okay. Okay, so we've got a number of red line changes. Are there any, without lapsing into wordsmithing, if we can, are there any changes here that you feel like we need to discuss?
Rita, can I interrupt really quickly? I'm looking at the version that's dated 11/16 on board books, and so this section is actually on page 5. I just want to make sure we're all in the same version.
Okay. So
unless I'm wrong.
There are 2 documents in the board book. One is labeled 11/16/2020 Policy Committee Draft Red Line Version. That's the one with the new, what we call the preamble. And the other one was the revisions to the existing complaint policy, which is what I used for my notes. So for that draft, it's page 4 of 8. For the other draft, it's page 5 of 9. So either which. The only difference in the 2 drafts is the very front part, the additions with the preamble. Right? Okay, so any issues that require discussion in the section on step 3, appeal to the PPS board?
The whole section? I mean that. So all of B and C. No, all of B.
All of B.
So just in the sense of everybody having the same information. It seems that if there have been board questions and answers, that that would be part of the written background information provided to the complainants as well.
Is that a question?
Well, I'm just, it's a I guess a statement that the written background information, that everybody have the same, again, the theory of everybody having the same information.
So are you suggesting that we add some language to what's here, including?
Well, I guess that would be my question. That would be my question if that's that's included because that hasn't been the past practice.
Including
What's the question, Julia? I want to make sure I've got the, if we're looking at a different, depends on the draft. One draft is redlined to last versions, the last meeting's version, and one draft is redlined to the current policy. So that is new language. And maybe I'm...
Right. And I'm sorry, I'm looking at the one from my version from last time, which is what I have my notes on, but it appears that it's the same as the one that I printed out yesterday.
Yes, that has not been changed from last meeting to this meeting in terms of new proposed language about the 24 hours and exchange of information.
Right. So originally when I had raised this, because I think this was language I had added, it was thinking about, and then I had an additional thought. It was thinking about, say, we get a complaint and based on either new thinking or something that staff sends the board of, like, here's additive information for your, other than the sort of established written record, which seemed like that prevents a complainant from walking into a meeting and getting some brand new information. But if it's going to be the written record, it seems like it should also include whatever information board members received in response to questions. So I'm just asking, so my question is, I just want to make sure that includes that.
So Julia, what you're saying is if I ask a question of staff in preparation for hearing the complaint, that question and the responding information should be provided to the complainant?
That seems, I'm trying to think why we wouldn't.
I think phrasing it, I think that's generally the case. You might have a legal question that's a privileged communication that would not be included. You might have some FERPA protected information that wouldn't be, I mean, I don't know all the different variations, but I think the general gist and the intent behind this language, even though it may need to be tweaked some more, was that information the board was considering generally is information that the complainant should see, was the intent of the edits I thought were requested and what we're trying to get to. So I think we're headed in that direction, but welcome suggestions. The policy, I think, is best framed in terms of what comes from the district to the complainant. I mean, it can regulate internal communications among board members, but that seems like an odd thing to put in the policy given how its other orientation to the complainant. But the information flow, what the board has requested and what we've tried to do is, I think, in that direction, Julia, but tell me where we can make it better.
Okay, so I totally agree with the two areas, and there may be more, that where you wouldn't share information, and I think we could be explicit about that. But say it says the district staff and the complainant shall exchange any other written background information they intend to present, and maybe it's just as simple as adding present to and just adding or share with the board.
So, what I'm hearing is, Julia, is you saying if I ask a question and staff answer it in a way that's sort of making a case one way or another, for example, that's information that the complainant might want to either dispute or add some detail to, but if they don't know that has been added to the argument, so to speak, or the case, they would have no way of responding to it. Is that
right?
Yeah. Okay. I think that's, and I would agree. I think that's, and I hear Liz saying that's the intent, except in the legal FERPA kind of exception.
I think present to shouldn't, I think the share with, because in present, these are short proceedings generally. There may be a whole lot of information. So present to, I don't think is meant literally in terms, at least in terms of how currently those processes have been, those hearings have been conducted. So I think present to is meant more in the share with category. Yeah,
because it's just not our current practice. So in some
Right.
ways, like board members are walking into the room with more information actually than the complainant, and it's information supplied by the staff.
Sometimes that may be the case, yes. This is meant to make sure that the complainants understand the basis for the board's decision and the information the board was considering, I think is how I would characterize the intent. And it's the board member's intent that we are trying to translate, so I want to be sure we get it right. My questions and explanations are in furtherance of what you're trying to solve.
And so is it and I want to understand if I may, what we're talking about, formal requests for additional information, or you're having a conversation with somebody and a staff member and something comes up? Because I think trying to ensure that everybody understands both board side and staff side when we are providing information that we then therefore have to provide to whoever's, kind of leading the complaint forward.
I was thinking it in terms of written questions and answers, just because those do get shared with the full board. But obviously, if the people have different styles or maybe thoughts on.
So do we have a specific proposal on the table for language?
Well, I just would suggest after the words present to add or share with.
So share with, or almost a shared with as well, because there's share with at the formal hearing, there's shared with before the formal hearing. Sorry to get really wordsmithy, but I think that's I'm hearing the issue Julia bringing up.
I think the appeal hearing may be more prescriptive than was intended, because it's taken literally, that's a point in time. And what you're talking about is the materials the board is considering for the appeal, I think. So maybe we can tweak that to make it less tied to that time period and more about the information being shared with the board.
Okay, and you probably, given the earlier discussion of there may be circumstances under which particular types of information won't be able to be shared. So work your magic with the words. And okay?
Mm-hmm.
Okay. Anything else?
I noticed, sorry, this is Ailey. I noticed that in the step 3, it says we have to hear it within 30 days. I'm on the 11/16 version. That says the board will vote on the appeal within 30 days of the written request to appeal the superintendent's discussion. I know that we have delayed multiple times based on us asking for a delay from the complainant or the complainant asking a delay for us. Is that something we should put here in the policy as something that sometimes happens, or do we leave it in this way, just all knowing that stuff crops up?
We have something on other provisions that says that it can be delayed by mutual agreement, and I don't know that it specifies on which level we're at, but I don't know that we need to do that.
We can make it clear that it applies at any point in time.
Any point.
Okay. All right. Can we move on to C, other types of complaints?
So question about, it says we accept anonymous formal complaints concerning Division 22 matters. And I know we've now added in with a Division 22, but it seems like people may look like, well, I don't have a Division 22 complaint, but I have an anonymous complaint. Like, where do I send that? So it seems, I don't know, are we,
We take anonymous complaints in a number of settings through a number of intake mechanisms. This is one of them. And this is the Division 22 formal complaint policy. So I think that's the clarifying edit there. We need a place for it to go. So we know that for this regulatorily required process, they come to this place. I think it's not to limit anonymous complaints in other settings, but to make sure we get the anonymous complaint under Division 22 in an identified place.
So I think when we work on the language, the preamble language, which we're not going to call a preamble, but for the sake of this discussion, the preamble. Yes. But this may be one place where we might need to tweak this document just a little bit and clarify that, you know, everything that we're talking about right now is part of a formal complaint process. In which case, you know, the Division 22 stuff comes in. Anyway, sorry, I interrupted somebody. Was it Scott?
Yeah, I was just going to say, well, Division 22 might be why we have this policy. The public doesn't give a rap about whether their complaint is Division 22 or not, and so it might be. I think there should be a broader statement that goes beyond the just the Division 22. Just to say, well, you know, doesn't it have to be Division 22 to make an anonymous complaint?
I think we can rework it so it's more clear and less, and the whole point is that people understand it. So we'll work on that.
So maybe, sorry.
No, please go ahead.
So maybe after the first section where we talk about this conflict resolution other than the formal complaint policy, then there is actually a preamble that talks about various types of complaints. And it could be Division 22 is like the formal, or, you know, these types of things. There's also a whole other host of complaints, and here's where you go for those. Because to me, as saying like, hey, this complaint email, this is only for Division 22, and I think I agree with Scott. Like, until I got on the school board, I didn't even know there was a Division 22. And so I think just in plain English, we should be describing, you know, where people go. And I don't know why we'd only have formal complaints. I know why Title IX we might have a separate place, but if something wasn't Title IX and wasn't Division 22, where would they go?
On the conflict resolution webpage that Lydia created, there is I don't know, we had that, you see that we refer people there, and it does talk about what number you call to make anonymous complaints. It also lists the Safe Oregon hotline, which is also where you can make anonymous complaints. We can perhaps provide greater context rather than just say for other complaints go here, so that people understand that the web page offers a lot of different avenues.
I think what would be helpful, though, I mean, I want to make sure that people who have concerns, I mean, I think doesn't matter what I think you want, but I happen to agree with. We want to have people know where to go, and we want to welcome concerns in all avenues. But one of the purposes I understood of the revised language on the front end was to not make this entirely about complaints. And I worry if we start building paragraph and section after multiple kinds of complaints that we've undone what the intent was in the front part. So I guess I need some clarity as we're drafting about how to frame the information in which place, and whether all of that's in this policy, or are we trying to say, here's how we'd like you to work through, and these are the informal ways and the collaborative ways and the closest to the work ways that you described earlier, Julia. And then if that doesn't work, here's this process. Or are we trying to say, if you have a concern about this required process or any of these other places, here are all the places you can go to complain. And I think those may be send different messages, and I want to make sure we're understanding what you're trying to accomplish.
I would just add my 2 cents into this conversation is that this is the complaint policy. This is not the complaint process, right? So the process that's on our website for people to find is not necessarily the verbiage in this complaint. So if someone's rolling up to the PPS website looking for how to make an anonymous complaint, Julia, the exact language in this policy may not be what's on the website. So I think it depends on how we're thinking how users are going to encounter this language.
So I would, that's a great point. I would hope that they would be not in conflict or be aligned. And maybe the thing in the section that is no longer the preamble, maybe there's just a reference to, here's a general resource that you can go to. And then when you get into the formal complaints, be explicit that these are Division 22. But if there should be somewhere in PPS, and if it's the website that has all these other places, then we should steer people to that at the very beginning. And then we can go into, and here's the formal Division 22 piece. But if you're following along the complaint process, like I found the policy, now I know what to do, and then it's like, oh, but actually I'm in the wrong place because this is only for Division 22. So maybe we should.
So can I stop us here, because I think what I think I'm hearing is that this can be dealt with in the process of coming up with a new introductory section, and fold this kind of information into that up front rather than here. Does that sound reasonable, Liz, Mary?
Director Moore, just so that I'm sure that I'm understanding the conversation correctly, I think we want to convey that we want to have a culture where folks are welcome to lend feedback, express opinion, displeasure, whatever it may be, and we encourage them to do that with their child's teacher, with their principal, with their school supervisor, etc., in a multitude of ways. But for Division 22 purposes, that the board is outlining a formal process with specific steps to resolve those.
Right. Yes. But I think the thing we're talking about is, these are the pieces that are not necessarily Division 22. So moving to the front under a different, in that introductory section, and that's a logical place to put it. So I'm suggesting that unless I hear from Liz otherwise, I think we've given enough direction at this point, and we're veering close to wordsmithing at this point. So do you have enough to work on, Liz?
I think so. And we'll be sure to not call things Division 22 matters, because I agree with you. That's not helpful to people. So, yeah.
Okay.
In addition to the other things you've talked about, but I wanted to know we heard you on that as well.
Okay. All right. I'm going to move on to D, other provisions. So I think as we work through this new introductory thing, I think some of the things in this section under other provisions we might want to move up front. Things like number one, the following, district will provide the following resources. Or not. I don't know. I think it might be worth going through this long list of things and seeing where we might need to shift things around.
So the only assistance that we're listing is translation. Yes. And I'm pretty sure that Lydia, amongst others, helps people, kind of walks through what the process is. Not about the content of what they put in, but about here's the next step and here's the timeline and all that kind of thing. So it seems like we should list something like that. We're going to say that. I don't know. Maybe she just sends them the paperwork and says, "Good luck."
No, Lydia is the star of the show. She helps families all the time, so we really appreciate that. It's an important role. It's a good call out, Scott.
So we're on D, right?
Yes.
So one thing I've heard from a number of complainants is the sense, and these are often parents who've like their first time in the system, that it's super intimidating coming into a room. And I know in COVID it's like very different, but coming into a room where, we limit in number 4, we limit them to one other person, and they walk in a room and there's like, as they've said, like you've got the board, the superintendent, lawyers, a whole bunch of other staff member, in a sense of like, I'm like completely outnumbered here. And I don't know what the language is, but I keep hearing this is like, it's super intimidating, and for the average parent to be in that situation and like, I'm not sure really what to expect. I'm nervous. And then there's, I didn't know there were, and I'm sorry, Liz, like I didn't know there were going to be lawyers in the room
Yeah.
or like, I didn't know who was going to be there. And so I'm just thinking about like, and maybe this isn't in the policy, but just our practice of like, here specifically, especially when it's a student, when it's one of these closed sessions,
It's inarticulate language because much of the time it's a public meeting. So first of all, in a public meeting, anybody can come. And then when it's an executive session, then I think that's really, and so I think it's a good point that is imprecise given what happens. And it may make a complainant feel unduly restricted in who they can have there as support. So we should talk about if you want any guardrails on an executive session, right? It's some nexus, but a public meeting, they can bring anyone they want.
Right. And so I think some of most of these have been like student related, where I've gotten this feedback. And so, I mean, like, do we need all the staff in the meeting? And if we've already sort of laid out all the information, is that necessary, especially if we're going to be telling them you can only bring one person?
I think it's hard in a policy, and maybe I'm not thinking very creatively because it's been a long day. I think it's hard to define on a policy basis across the board how you would define which staff can be there, because a particular complaint may require more, 3 people, and another one might actually require 7 because the people to be available to answer questions for the board. So staff is there to be helpful, and there's sometimes you might need someone who's a counselor versus someone who's in the administration of the building versus the person who did the step 2 complaint, who's the boss of the person in the building. I'm just thinking through all the roles that are implicated. So it's hard for me to get my head wrapped around how to define that, unless you want to say every staff members need to have information relevant to the complaint. But I don't know if that solves the concern you have either.
Even be another thing is so I can see a complainant saying the same thing, like, I'm a layperson, so I need to bring X person and X person, and you only said I can only bring one person.
Yeah, so I think we should change that language anyway. I do think we want to think about an executive session is a confidential session. So it's hard. I think we're hard pressed to tell a family. I mean, it's their private information that's being protected, and these are FERPA protected proceedings. So if they want to bring someone into that conversation, I'd be hard pressed to start drawing firm lines.
Right.
I may not have thought through every piece, but it's their privacy and their child's privacy where those rules protect. It's not the district's.
Right, but in theory, if they're the person inviting them or bringing them, like, it's the assumption that they've agreed to share that information.
Yeah, I haven't thought through all the mechanics of that, Julia, but it's as a conceptual matter, I think that's right.
So it's, I think outside of policy, we might want to think of other ways to sort of some pre-hearing ways to ease people in.
And Lydia has developed some very nice materials that she now sends out to every family before they come. What I'm not recalling, Lydia, is whether it talks about who can accompany them, and that maybe in more generous and welcoming terms than the current language, which we'll revise before the next turn of this. But do you want to speak to what you tell families and the information you give them?
So the information that I provide for them before they come in, I display them with all the background information, and then how the proceedings go. Like if they want to speak in front of the board, they have X amount of time, and then they can remain there if the board has questions. But I do not specify how many people they can bring in. Most of the time, both parents come in if they are both available. But I do not specify if they can bring more than one, more than two.
So I think we can revise that, Julia, because I think we want to respect different family and cultures and support needs, and I think that's important.
Great.
Okay. Okay, any other issues?
Yeah, in number 12, who is the determinant of what has been previously filed, investigated, and responded to? And my assumption is this language has been run by ODE, and they are okay with us rejecting a complaint.
I don't think the specific language hasn't been run by ODE because it's just making clear to participants what I think is already in the ODE regs, which is if you are unhappy with a decision that you have at step 1, you go to the next steps, and if you're unhappy with the district's decision, you go to ODE, but you don't start over again on the same issue at step 1 with the district. So it's just making that part clear to families. It's not, I think it have to be anything that is not all tied tie goes to the runner, and the runner is the complainant, right? If there's any ambiguity about whether this has been addressed before, then it's not been addressed. But if it has been addressed, you don't get to start over on that process. There is finality at some point. If you don't like what ODE does, then you take it to the circuit court to completely over-lawyer the answer. But there is a path that already exists. This is intending to reflect that.
So I would say two things about this one, that we should make clear that that's the process, and put in here that they can go to ODE. And then I know that there's a whole process of a first reading, a public comment period, and the second reading whenever that happens. I think in the meantime we should get the AD fixed, because if you go to the AD, it says that the board is the final, and if actually it's not the final, we should add in here, like, hey, if don't refile it. If you don't like it, you go to ODE and then fix, at least right now, for whatever the 3 to 4 month time period that it's going to take to get the policy through the process, to get the AD corrected so that it's aligned with state law.
I agree. I'm fixing the AD, and we will put that work stream in motion for the superintendent to review and ultimately sign off on or not. But I'm sure he will, because he likes to be compliant. I know this about him. So,
and Julia, I would say,
yeah. Yeah, but there is
the step
section
3.
5. I'm sorry, Andy, go ahead.
Now, I was going to say, under the step 3 appeal, after it's like step 3 appeal, and then it says if the complainant is not satisfied with the decision, then they do these next steps. So I think that's already covered here about what those next steps are there under step 3.
Except for the AD says the board is the final arbiter. It just needs to be fixed.
Okay.
What happens if there's new evidence? A complaint gets decided, and then that videotape of me comes out, and so it turns out the complaint was right after all.
So I think there are a number of permutations of that, Scott. So this is not a court, right? We don't have rules of evidence. I think there are a couple paths. One path is, if there was any sort of deception or, improper conduct or motive on the part of any staff member, I think the district would step up and do the right thing, right? This is, that's what this place is. If there is imperfect information at the time of a decision, and later there's just more information, I'm not sure you get a second bite unless the district decides to. Again, this is one path, but I want to be careful we're not setting up this. I made a public records request after I went to ODE, and then I got all of this new information, and now I want to go back to the district again. We don't. This judicial-like function is a sliver of what the board does, and outside the normal operations at the board level and at staff level. So I have concerns about making it too quasi-judicial. I mean, I think we do our best to adhere to and provide fairness and due process. There are due process claims that would be available. I would surmise, I haven't thought through all of them. If someone really, was done wrong by the district in this process, might be other claims. That's not what a family wants to do. A family wants to be treated fairly and find resolution if at all possible. And I think there are multiple paths. So I don't know how to write that in a policy answer to cover all of those steps, but I don't think sitting here that just new evidence without other extenuating circumstances should have you start over, because we don't purport to have an entire universe of evidence on a particular issue. So like if there were a dog park issue, right, and we're talking about one dog park, but now we got evidence of other dog parks that came in after we decided the issue about the one dog park. I'm not sure I don't think that's what this process is designed to do or consider. but it's not my process. So we have to meet the Division 22 requirements. And if this is what the board wants, it is your process to define. But that's my initial response when I think about it.
I mean, obviously, here's maybe a potential practical solution. If the evidence is like super compelling and it's an issue of like importance, the board can always waive its policy. As a practical matter, though, it says for the vast majority of them, if the new evidence is immaterial, like this is the policy.
Okay, I'm good.
I mean, just
Okay.
I have a little bit of a follow-up.
Sorry,
Okay. Justin, go ahead.
So I'm just thinking of an incident where what if an incident happens and then that gets reported and it gets resolved, say, in the second step, and the family or student says, yes, that works. But then what if the same incident or a similar incident happens again? I mean, obviously it wouldn't have been resolved, right? Could they then, okay.
It's a new incident. I mean, unless the issue is, I'm going to go back to the park setting because it's simple and easy. Right. If I don't like the sign, if I think there's something wrong with the sign on the school grounds, every time I look at the sign doesn't create a new incident. But if there's a different sign, or that sign, we've resolved it that the sign's going to be taken down, and then another sign shows up, right? I mean, if we had a resolution, or if a different sign I don't like, it's similar but different. I mean, it's you get one shot at the same incident, the same dynamic. So there's some subject of complaints that are about how things are operated or run. They're conditions that will exist, and so they're resolved one time, and they will continue that way despite multiple interactions by a family or student with that process system building thing. Does that make sense? Yeah. But I think I do think it's very generous, and again, tie goes to the complaining party, right? If it's ambiguous whether it's been processed or not, we want a process that is accessible that way and not overly formalistic, right? We want to resolve the solution. We want to resolve the problem. We want to understand if it gives us visibility to systemic issues. We're not trying to create a court-like setting.
so I just reread this, and not to belabor the point, but how I'm reading this is like if one person files a complaint and they're like a kind of an incompetent complaint filer, and the district feels it's been investigated and responded to, it appears that's the complaint. Like somebody else couldn't have a separate complaint about it.
I have to think through, again, all of the different ways that shows up, Julia. So if it's about the same immutable incident that applies equally to all people, right? The bus route. I have a complaint about this bus route. And family A says, I've gone through all the steps through complaining about this bus route, and I don't like it. Does family B come and complain about the same bus route in the same year? I don't know. I mean, I think there's a high likelihood of variation there of new issues, but I suppose there could be some, if you had 20 families who were complaining about the bus route, you wouldn't serially do it 20 times either. So I'm trying to figure out where that is. I think this language was drafted with the idea that the individual complainant doesn't start over again. And I think most complaints are about a particular family, but I can't tell you there are none where you wouldn't say out of the, for some sense of efficiency, you could come up with some absurd results in both directions, I suppose.
Yeah, I mean, it's interesting because I was thinking of that exact same way, that like it's the same person, but then I read it, it actually is not specific to a person filing the same complaint.
I think Division 22 is going to give the nod to this being limited to individual complainants and not, I don't think that Stephanie's family can exhaust my rights. So it may be a truncated, I mean, it may move through quickly, but the individual rights by each family to complain about the bus route, I don't think anyone else can exhaust mine. It's probably,
Okay.
I mean, I'm thinking off, I'm shooting from the hip here on that one. I haven't thought through all the nooks and crannies, but I think that's probably right. It's an individual appeal.
Can we move on? Are there any other concerns?
Director
Yeah.
Moore, I'm late to the party, so you might have already covered this. If that's the case, staff can brief me later. But in 1D, this notion of an annual report, I'm assuming that's a summary of the formal complaint trends. Did you want my assessment of how the process from staff perspective? And I know Lydia always does a really nice job in summarizing those. Were you looking for something different?
Where are you?
1D towards back at the top.
D as in dog?
Yes, ma'am.
I'm not seeing a 1D. Oh, annual report. Yeah. Okay, I'm seeing a 1B.
It's a red letter A and then a D in blue.
Page 3 of 9, Rita, on the version from the 16th. It says, because complaints can be an important indicator of the health of an organization, the superintendent will provide to the board at least annually data on trends and emerging issues, as well as an assessment of the formal complaint process.
Okay, sorry. So it has become clear to me that there are differences in the text between these two versions. So we're going to be using the 11/16/2020 version as the baseline. Okay, so sorry.
Okay, I was just looking at the posted material.
Well, both of them were posted, but anyway. Okay, so the question is the superintendent. I think it's the superintendent as a metaphor for the district. So maybe we should make it the district, not the superintendent.
I just want to be clear on sort of what you were looking to describe in the way of an expectation. So this is a formal complaint policy. So you want an annual summary, I'm guessing, of all those that were filed, how many went through step 2 or 3, you know, did they result in, you know, resolutions or support or other direction, as well as an assessment of the process. Are you looking for my opinion of the time and effort and resource expended, or, for example?
So the
good.
kind of trends of, you know, we've had 18 complaints about the coffee in BESC.
Okay.
Time to do something about that.
Okay. So a summary of the trends, the types of complaints, are they coming from a particular area?
Right. And sort of emerging issues, like what should we, based on what we've heard, we're paying attention to this. And I mean, personally, I would like to see, I think it would be helpful to know if some issue areas needing improvement were identified, and if so, what was done or what is being done, that kind of thing. What we were trying to avoid is being too prescriptive in the policy. So I think we were refraining from being more prescriptive because I'm pretty sure we could be. You might not want us to be. But anyway,
okay.
Does that answer your question?
Yeah, we'll provide a summary of formal complaints and any patterns or trends. to your point, there's no shortage of improvement areas, but we're not
Right.
tabulating, everybody's opinion about all the things that we need to work on. This refers to something more specific.
Yes, yes. Okay. Okay, back to the other provisions. Any other?
Yeah, on number 13. So I find problematic that I have a question about the second part of it, but the first sentence, not knowingly refrain from initiating or pursuing contact. So currently the board is not informed when a complaint.
Which one are you talking about? Which number?
Number 13. So currently the board members, they wind their way through Lydia and the process and the long response. So oftentimes the first time we know there's a Division 22 complaint and it's coming to the board is when we get a notice from Lydia that we're going to be scheduling something. So, I don't know if a board member would even know that. Then second, so complaints come in different forms, and I think often we may be thinking about one or two particular examples and then write a complaint to address that when it could be much different. So for example, I'm going to take in 2014 the Parents Coalition, where you had actually 10 parents filing a complaint with ODE. But there were, hundreds of high school parents who were supportive. They were just named complainants. And so I'm just wondering how that works. And then also how it works if, so say, for example, we've got somebody in the pipeline with a complaint that lives in Lentz, and they're participating in the Southeast the Southeast enrollment balancing or middle school opening process, and they contact you. I don't see how this is enforceable. Or, as we found, somebody could file a complaint and then their spouse shows up, or their ex-spouse, or their advocate. So I think it's hard when we're elected officials, we get contacted by a lot of people, to have that be an enforceable or even necessarily the right thing to do.
Okay, can I clarify just a couple things? So first is the point you're talking about is number 13 in the original document. In the November 16th document, it's number 14, for those of you keeping score.
Right. I didn't transfer all my notes from one to the next.
Yeah, okay. The second thing is that the language in this paragraph is still somewhat garbled. So we need to clean up that language. But okay, so getting to the.
I think the intent of this is really clear. That's here. It basically means that we should not knowingly initiate or continue or pursue contact with complainants once a formal complaint. So, Julie, if we don't know that a complaint's been filed, then that's not a problem. But I think it's all about, once we know there's something going on, how do we interact with that complainant, right? So I've had examples where somebody's got a complaint and the person contacts me about something totally different, and we have a conversation and work on that. But I think this is about us as board members doing our own investigations or sort of unilaterally trying to resolve complaints or do stuff not as a collective. And that's what this speaks to me.
Yeah, but this just says, so for example, and I know all board members do this because I see a lot of the responses, is somebody contacts you, even if they're a complainant, people respond.
Well, and I mean, I've responded to people who have sent complaints, but I think there's a difference between what this is going to initiate or continue or pursue contact with complainants. So I think, just there's a way to graciously respond and say, we're in the formal complaint process. Thank you for your willingness to continue bringing these issues forward. Without getting into like that engagement piece.
Okay, well that's not what this says, and maybe that's what gets fixed, because it's implying that you can't respond to somebody who has sent you something. Okay, and then the other question I would have is what's the definition of investigate? Is that you have some technical expertise because of your professional background, or you live near the school where a complaint's at, and it's I totally know this answer that the district gave is wrong because I've walked by that place a million times, and there's X there. What does investigate mean? Does it mean looking up the meaning of a word or a phrase or a legal definition, or hey, I know somebody who's in that PTA and they offered this, very different version of events than the district offered? What does investigate mean?
I would think that investigate, I think any knowledge that we already bring is fine, and I think it's working through that with the senior staff. I think for me, investigate is, calling a principal and asking them questions, or calling a PTA president at the school and asking questions. I think it's, our role as the board is to work with that senior level staff. So I think it would be that piece. And if you know something of hey, I've walked past this park and I've seen this, then that's something to share with, the head of OSP as we're doing this work. That would be, and if you need to look up a word or ask a question, I think that's doing due diligence as opposed to investigating, questioning. I think investigating to me goes to questioning directly people involved in the complaint process at the school level.
So that means if the staff or superintendent invites you to a school visit about the impacted school, you should say no because, or you should go and you're going to get the district's version of things, or I guess I'd want to have a more clear definition of what investigate means, because I think it's open to interpretation, because I see individuals, like I say, this is part of the strength of the board. Everybody has relationships. Something happens at Ockley Green, Rita and Scott know people there, or Rita and Paul knew people there, and a lot of times that's the advantage of a board with deep community ties that may or may not be in a sense of place that we bring to the process. I'll just say the dog park. You just go, you walk by Richmond, and there's two different signs that say two different things, and by the way, they're full of graffiti, and that wasn't in the district staff report. And so, is that investigating? Hey, there's two signs outside, and in that particular case, so if it's hey, you had that information, share it, which I actually, in that particular case, send it to Claire. But I think we should be more clear about what that means, and so there's not a got you, it's okay if I do it, but if I use my community connections, but you shouldn't offer yours. Or, for example,
I think for me, it's the difference between going on a site visit to a school and hearing what the superintendent has and maybe asking questions, and then calling that person later and asking specific questions from the complaint, right? Those are different. And, there's a way to I don't think any of us should be directly questioning principals as board members. I think if we have questions about the complaint, that there's a pathway to do that, right? So I think this is all trying to understand if we have information as board members to share it. But, if there was a complaint, let's say about Llewellyn, which is where my daughter went, and I have very close ties to that community still. And in fact, there was something that came through about Llewellyn at one point. it's not my job to go call the teacher that it's involved and say, hey, tell me about this parent, or the principal. It's to say, when we get to, if I have a question or if I see something in the complaint things, to share, hey, I know this piece of information tied to the community. But I don't think it's my job to go in and try to resolve it at that level. It's my job to share that information with the staff who are doing the complaint response.
Yeah,
So
I didn't suggest that.
Can I ask a clarifying question? Which is that, let's see, going back to the language. This says, for example, should not initiate or continue contact once a formal complaint has been filed. Does that mean the formal complaint, or is that when the level 3, the step 3?
Well, we don't even know when a formal complaint's filed, so I mean, I don't know how we could.
But if you become aware, so you're, let's say you're talking to somebody who has a complaint. In the course of conversations, you discover that person has, in fact, filed a formal complaint. You now possess knowledge that a formal complaint has been filed. So at that point, this would kick in.
And then I think the point is to say, I hope you can work things out, outside the complaint process, keep talking. I hope I don't see you in another month. Step 3. But beyond that, let the process work on its own. We're not the problem-solving body in that sense.
Go ahead.
Sorry, I understand not contacting the person directly and trying to fix the problem at that stage before it gets to a further stage. What I don't understand is not allowing board members to make sure that the information being provided to them is accurate, or that that information is the full information that needs to be brought to them.
The board can
to make that decision.
Yeah, the board can request information, Jackson, and we get, and so the question is, if we have questions of the principal, we ask them during the hearing, right? It's that we do have a chance to ask these questions or bring forward it. Are we doing it within the process as a collective, or are we doing it on our own? And I think, and also it's staff's job to respond to the step 1 and step 2 complaints and try to resolve it. And so if we know something that can help resolve it, then we should be sharing that with those staff. And then when it gets to the step 3 appeal is when we can ask those questions and say, and we've said before at step 3 complaints, we don't have enough information, or we have a question about this that's not resolved. Can we delay making a decision? And we have. So it's really that it's the issue of, are we working together as a board in the process to make sure everybody's clear and the boundaries are respected. But our goal, I think, is for all of us to resolve this well and to fix things that are broken, and to also help, make sure people feel heard and that the process is fair. But we can do that. It's just, if I were to call up, let's say someone at Cleveland had a complaint and I was to call up, Paige's science teacher as a board member, that's super intimidating. So it's, how do we do it in the process in the proper way is kind of that piece, and respecting the hierarchy of staff.
Well, then I think we should have
Right,
something.
and what I would say, Julia, can I interrupt, because I haven't had a chance? Okay. So we're going through a great deal of time and trouble to create, we have created, and now we're revising, we're improving, a formal complaint process. In order for that formal complaint process to have integrity, we need to allow the process to work as intended. If we have a board member doing an independent investigation in parallel to the official complaint process, that is going to interfere with the integrity of the process. And I think in terms of, earlier there was a lot of discussion about what qualifies as an investigation, and I would say I think reasonable people know what constitutes an investigation and what doesn't. I mean, noting that, I was walking down the street today and I saw the sign in question and I noticed X, and you say that to the staff person. Obviously, that's not an investigation. But if somebody is conducting an investigation that involves multiple phone calls to different participants in the issue in question and reaching conclusions and checking up on things and maybe advising the complainant about how to approach something or what to ask, that's an investigation. And I don't think that is productive because it's going to undermine the integrity of the formal complaint process we're trying to set up.
Yeah, so
okay.
There's multiple examples over the last 2 years in which the board either got inaccurate information or not all the information. So I think when everybody saw the video, for example, of the assembly, it was like, oh, that was clearly like planned. But the video was never, even though that was an essence of a complaint, like it never got put onto us. And so, it's, if a board member gets, here's another example. Before there were any sort of complaints, everybody on the board got well, not everybody, some people got photos from an assembly. And at a certain point in time, staff said, hey, I don't know where those photos are. Could you give them to me? And there's supply to them. It's like, I don't get what you're implying is an investigation when actually, often staff, most cases, staff and board members are equally copied on the information. So I'm just not understanding the difference. Or I also think if we're going to say that we can't get anything from the complainant, I don't think it's inappropriate for staff to be, for example, inviting us to a school where the subject of the complaint is. Because that's, from a parent's perspective, it's like, oh, well, so you got information from one side and there was no limits on it, and yet...
Okay, here's the thing. Okay, I get your point. So here's the thing. We're either going to have a formal complaint process with procedures in place that is implemented by staff, or we're not. Pick one. You can't have both.
That's great.
And if at the end, if the board, let me finish, if the board has a role in that formal complaint process as the venue for the final appeal, then I do not understand how a board member can play that role with integrity if that board member has been screwing around with the process throughout. And we have had cases where that has happened. And I don't think it's productive. And this paragraph is intended to implore board members to allow the formal complaint process to function with some level of integrity.
Okay,
and I would agree with you, Julia, that if there's a complaint about something going on at X school, and I was scheduled to visit X school in the next month, I'd reschedule. I think that's what we should agree to as a board.
Saying, let's just call it out. Like, I got invited by the superintendent to go visit the school right before we voted on the complaint. So,
And that was after a long period of you taking independent action in parallel to the official
there
complaint process.
was no independent action.
Okay, all right. I'm gonna call the question. You're clearly not going to agree, so I'm going to call the question. We need to work on the language. We need to fix the language in this paragraph. But I'm going to ask for a formal vote among board members.
Okay, I'd like to add.
In principle, who is in favor of this paragraph with potentially some relatively minor revision? Okay, who is opposed?
I'm opposed.
Okay.
I think it's not defined, and I think it's going to be impossible to actually implement with intentionality. I'd like to propose language that we add some sort of, doesn't have to be formally done now, but that just like we're not going to have contact with the complainant, that staff will also refrain from discussing the case outside of the normal processes, which is the written record and anything else, with board members. Because my concern is that parents already feel the deck is completely stacked against them, and that if we're saying, okay, here's the set of rules, then it should apply to both sides. If we're going to be the final appeal, then it shouldn't be one side can continue to have one-off conversations.
Okay. All right. I'm going to ask you if you want to propose new language. Write up the proposal, and we'll consider it at the next meeting.
Okay.
Okay. Okay. We're now at 5:49, and we haven't taken a break yet. And we're waiting on schedule on the agenda. So we're very close to finishing. I don't think we have any significant changes. Can we power through for another 5 minutes and maybe get it done?
I think that's it.
Chair Moore,
Okay.
may I just add a point of clarification? If you're not familiar with the complaint process and the history of it at the district, I just want to state for the record that the staff who's in charge of the complaint policy has never withheld information or had side conversations. I feel like someone on this call was insinuating that she has not done her job appropriately, and that I just want to make clear, if anyone had any question about that, I just want to make sure everyone knows that I can attest that Lydia is an amazing complaint coordinator, and there's no record of that. So I'm not saying that was the intention, but if that was the perception that came across, I want to be really clear. Lydia's on my team, and I stand by her absolutely, and I know the superintendent does too. I know you all do too. I just want to make that clear.
Yeah, thank you,
Okay.
Stephanie, for raising what may have been my perceived what I said. I actually was speaking about the substance of the responses, not the complaint process, and I absolutely agree. Lydia is amazing, and all the complainants, they can complain about the process, but they don't complain about Lydia. So thank you for letting me correct the record. It's the content of the response.
Lydia, I'm sorry. I just want to apologize to Lydia because I know that sometimes we are very careless in our language when we talk about things like this, and wanting to get information and stuff. And so I just want to make it clear that when we speak about the staff or the district, we do need to be careful in our language and remember that those are people that we know and work with us. And so I just want to apologize to you for that sort of careless use of language we were using as we had that discussion.
Thank you.
Thank you for the work you do.
Okay. Okay. Thank you for that. All right. So let's see if we can finish this and then take a break. So E.
That was the last section, wasn't it?
What?
Am I missing something? Is there more to this draft?
there's E, complaints against the superintendent or members of the Board of Education.
Oh,
Which in the new draft is the very bottom of page 7 onto page 8.
right. Yeah, I just didn't see anything marked up there.
There isn't, but I just want to make sure, are we good? Okay, I'm not hearing anything, so I'm going to call it good. Okay, so Liz, you have a number of issues that you're going to come back to us next time in response to what you heard tonight. Julia, if you want to propose some alternate language for that paragraph, please send it around before the next meeting, and then we will put this back on the agenda for the next policy committee meeting in 3 weeks.
Isn't the process that I thought Scott and I were going to?
Yeah, we'll work with you in between now and that meeting too. Yes, I was going to say that. Yeah. Yeah. Sorry, it's still new. It's not.
I have one other thing that I think there was a misunderstanding on the public engagement process. That when it was presented that people who went through the complaint process would be contacted, and when I went back and looked at the suggested engagement, it's not all the people, and I just want to note for the record, I think we should talk to all the people who have been part. It's a subset, but I think we should ask everybody.
What section?
It was in the public engagement plan that was presented to us a couple meetings ago.
Yeah, thank you for the opportunity to clarify. We plan on sending the survey that we sent out to all of you for comments to all complainants.
Great, thank you.
Okay, I'm going to pause here. Can we take a 5-minute break? Get back here at 6:01, and then we'll move on.
Going to do time certain for public
yes.
comment?
Yeah.
Okay, so that's on at 6:50, period. Okay, good. Thanks.
Yeah, so we have less than an hour left. Okay, all right. Agenda is a draft policy to respond to the All Students Belong legislation. So you got a draft, and the recommendation I got was that this is very much a draft, very much a pretty early draft. So it's probably less productive at this point to think in terms of, actual wordsmithing, which we're trying to avoid anyway, remember. But to think about this as a concept, and if you have any questions, comments, concerns, suggestions, in a conceptual way to provide direction to staff to come up with the next draft. Is that fair? So who is should I ask Danny to walk us through the concept, or Liz, who wants to do this?
I think Danny or Danny and Mary, but Danny.
Okay.
Yeah, I can take a thing, and Mary and I worked closely on this. So this policy came from the State Board of Higher Education's adoption of the All Students Belong initiative, where the State Board of Higher Education really wanted to sort of send a clear and unequivocal message about the use of hate symbols in any school environment. And so after really powerful testimony from the chair, Kimberly Howard, they adopted a set of rules for school districts to follow, along with the requirement for school districts to adopt similar policies to reinforce this work. And so what we've been wanting to do is to make sure that we were sort of looking at this policy through its very stated goals from the State Board of Higher Education, while also making sure that there is great alignment with some of the work that we've been doing at the district around our responses to hate speech and really firming up our protocols. So what you have here is policy language that is rather broad and high level, and we are currently working on an administrative directive that will have much more detailed information, including a sort of like updated, robust sort of responses to hate speech. You got a little bit of a preview of that in the election toolkit, where we, sort of really wanted to make sure that folks were very clear about the definitions of hate speech, about making sure that folks knew the difference between hate speech and speech that, affirms values. And we really wanted to make sure that we're kind of continuing to use our racial equity and social justice lens to really examine sort of how we can make sure that these protocols are in alignment with our vision and with our steps moving forward as a district. So this policy has a few parts. So the first thing that we did is that we love the concept of all students belong. We wanted to really sort of brand this policy for PPS so that our community would be familiar with it. We had some early interest from principals around really wanting to adopt this policy and really sort of feeling inspired by the language of support for Black Lives Matter, and specifically sort of school districts taking on like anti-Black racism as a sort of movement moving forward. So we tried to take the best of all of those things, and so we changed it from all students that belong to anti-racist learning communities. And so that's one thing to sort of for your review. And even though I know that this happens, I have 20,000 tabs open. I just closed it. So the other thing I would say is the so what we started with the purpose, where we described we described sort of like our commitment to racial equity and social justice. We tried to frame this in terms of our sort of how we wanted to how we want folks to understand our work around being anti-racist and opposing hate symbols through the affirmation of our vision and our racial equity work. We also spent some time sort of making sure that, like a lot of work, and you'll consistently hear this, is that we don't want to just sort of remove a symbol or sort of denounce a symbol, but we also want to make sure that we're paying attention to the experience of students moving forward, and so we're really linking this not only to school climate, but also to the educational experience for students. So there's that framing. There is, we kind of went back and forth on sort of like how far down the road to go in terms of a long list of definitions, and we decided for this first draft we would kind of limit the definitions that only are responsive to the language that's in this policy, but in the administrative directive we wanted to be really clear and kind of have a compendium of terms that are related to this, so that we were really crystal clear, for administrators, for students, for parents and educators, that we're really clear about through what all those different terms mean, what was the difference between all of them. And then I think Mary had the really great suggestion of sort of like making sure that with the administrative directive that we're also thinking about what's that professional development that links through, so that it's not just a directive or it's not just a policy on the shelf, but that it really is supported. So the sort of meat, if you will, of the sandwich is basically sort of where the policy lays out the prohibition of hate symbols, and then sort of lays out the sort of consequences if they're used. This policy focuses on three primary symbols of hate: a swastika, a Confederate flag, and a noose. But we thought it was important not only to sort of affirm those three symbols, that those were not tolerated, but also to give more information about the database of hate symbols that the Anti-Defamation League League keeps, and so there's an active link to that. And then the consequences, we wanted to make sure that there is some, that the administrative directive would sort of outline consequences and sort of how we approach this. But there is quite a bit of overlap in some of the work that we're doing around addressing online issues, the Title IX policy, and the student conduct and discipline policy. And so we want to make sure that we're really crystal clear in the administrative directive and that the policy gives room for this, so that there's clear understanding of what the difference is between each of those. It's just one moment. And then then there's also the that we're also sort of making sure that the expectation and the alignment is there in terms of student experience and creating a climate and culture for learning. So that's the work in a nutshell. Mary Kane, not only is she an excellent party guest, she also did a lot of heavy lifting on this, and we've been able to collaborate really closely on this. One thing I would say is that in meetings that I have with colleagues who have similar roles across the region, is that the use of hate symbols at sort of like, the city of Portland, the Clackamas County, Washington County, Metro, there is quite a bit of appetite to make sure that folks are really, trained up in sort of understanding how those symbols are being used, how young people are being recruited online, and how this sort of like plays out in different ways. So we'll continue to try to make sure that we're aligned with that and keep this policy body updated, so that if there's additional information or direction that you're sort of aware of that as well.
Okay. Any comments or questions? Scott, go ahead.
So the intent of the original that we're working off of was about all students belonging. This version that you have is specifically about anti-racism, and yet there's references to LGBTQ and other forms of hate, targets of hate speech. Help me reconcile the broader with anti-racism as being somewhat narrower.
Sure. And this is sort of like where some of the interplay in the definitions came through, because in the administrative directive, we want to make sure that there's a clear understanding of, say, like misogyny, sort of anti-immigrant sentiment, as well as xenophobia. But I think we landed on anti-racist for this policy in particular because of the intent and because of the connection between the three sort of symbols that were outlined. When in the state board's presentation and sort of rollout, they really focused in on the importance of the Black Lives Matter movement and sort of how this was connected, and that by creating a space where we are really attending to anti-racism, that in fact we create space for many intersecting identities to feel safe and to belong. It's been our theory of action that by sort of zeroing in on race and anti-racism, that can take us a long way in making sure that we've built the muscle to be able to then make sure that all intersecting identities are affirmed.
So I appreciate that, but sometimes there's not going to be intersection with somebody who's subjected to hate speech or a hate symbol. So that's you know, and the initial title sort of almost sounds like, well, all lives matter, kind of a thing, and I appreciate not wanting to cast things in that sense.
But are you suggesting that the anti-race, that the title is more limiting than what the intent of the policy? I mean, because what Danny has described, our intent is to be as comprehensive as possible. So I hear what you're saying about the title, maybe.
Yeah.
And I want to, I think we should be specifically calling out anti-racism and not doing a mush. But if, along with calling out anti-racism, I would want us to also call out other forms of hatred.
I guess some continued place for you to think about is that if you think about some of the objectives and the goals of sort of white nationalists and the sort of folks who perpetrate these symbols, I think nothing would make them more upset than sort of calling out anti-race. That would sort of the sort of singular focus on race and that sort of emphasis would be evidence of the exact opposite of what they aim for, and a lot of their reasoning can sometimes be about like, well, what about white people who experience this this other type of hate symbol? Why aren't you accommodating for that? And that's why sort of like Black Lives Matter or racial equity or DEI is problematic for them. And so I think that I totally understand what your intent and I hear what you're saying. I think that in terms of rooting out hate speech, I would strongly say that some of the best things that we could do for our LGBTQ students, for women, is to be anti-racist. That is a strong antidote to hate. Oh, sorry about saying DEI.
Jackson helps me. We're cool. It's good modeling to ask a question when you don't know what something means, right?
Mm-hmm.
So I guess maybe when we go out to public comment, we'll hear from other groups. I think the language should be centered on anti-racism. From hearing from the disabled community about ableism and certainly LGBTQI students about the issues they raise. We have a passing reference to that or even national origin that I'm not sure we've quite captured the broad spectrum of hate speech and symbols by this, and I would just open the aperture a bit. I'm interested in hearing more about, maybe this is more the AD, but understanding how it play out, because we can say as adults, hey, we know these things are hate symbols, so if they show up, we all know, a noose is the ultimate, act of racism or a burning cross. I don't think all students are, depending on where they grew up or, what their family's background is or their experiences they've had, would know maybe all the variations. Certainly the explicit ones that are mentioned, yes, but if there's a much longer list, I'd be interested in how we share with students what those are. And by the way, I was doing an independent investigation, and the link is not a link because I was wondering what the other symbols were. At least in my version, I couldn't link to it. The hate on display, hate symbols database, I couldn't find it. But when I went to it, it said I saw a whole bunch of other articles that had like the OK symbol being like co-opted by white supremacists. And, you know, it's like that's something people use all the time in like just responding to text. So like, I guess I'm interested from an educator standpoint of how we share some of the nuances or evolving, because the OK sign I don't think used to be the white supremacist, and I think a lot of people would still be surprised to know that that was been co-opted. Or like,
Julia, I was at a OSBA conference on this issue, and that's one of the difficulties is it's the symbolism. It moves so quickly, and it's hard for, I think, the adults to keep up. A lot of the recruiting tactics online in particular are moving very quickly with memes that seem innocuous to us, but hold great relevance and great harm to students who are also on these online platforms. And that's why what Danny referenced in the AD, what we're also conceptualizing is the educational piece. Like, what is this? What is this we're talking about? And how can we help students to recognize it so that they are aware when they're being recruited, right? They are aware when they're being drawn in, and because I don't know that we can list everything in the policy, that it's going to change too quickly.
Yeah. I think that Mary hit it on the head. We had, when we were training, when we were offering professional development at the Leadership Institute a couple years ago, we heard stories of sort of students who were, you know, innocently sort of wearing one of the symbols because it was adorable, and it was just because the administrator had seen you know, something, you know, had taken an interest, that they had seen that was in fact, you know, was sort of like a pretty common hate symbol, and the student had no idea. So I think what we've really tried to focus on is making sure that not only do administrators, but also that our custodians and folks who are in our facilities departments. So leading up to the election, we asked folks to sort of like do a double take around all the rules, making sure that graffiti wasn't sort of hate symbols, and just sort of making sure that sort of education. We have 2 schools who are currently implementing the ADL's No Place for Hate curriculum, and several schools are adopting different parts of teaching tolerances. So some of their pieces of curriculum around sort of like hate at schools. So I do think that there is an opportunity, and in our protocols we reference both as sort of like resources. We've also utilized State Center's response to white nationalism as well. So we are really trying to make sure that we've got all of the resources available, and that we're savvy in the way that we talk about this, because there is a recruitment that's happening. We can sort of see it. There is a sort of start with like questioning, and you know, and the interplay of misogyny, xenophobia, and racism are really, really strong, and so we want to make sure that we're very focused around what that looks like. So,
I'm really glad to hear that. From a standpoint of like a board member, it would be great to capture like everything you just said somehow in like a paragraph or 2 about how we're going to do that, because I think otherwise it could be hey, we feel really good because we passed this policy, but not necessarily indicating like how we're going to equip students and staff to, and I'm thinking primarily of the unintentional things that may be expressions of hate that people like, I didn't know that. And we live in a very white community in some ways, so it's some staff and students may or may not even know what we may think as really common things. So I hope we can capture some way that how we're going to help educate our community, even acknowledging that they're rapidly changing.
Yeah, I think we can
Okay.
accomplish a lot of that in the AD.
Okay. And do we have any other major, I'm looking at the clock. Do we have any other major comments that you want to give to staff? Danny and Mary, have you gotten enough to work with for the next iteration of this? Okay. Any burning issues that? Okay. All right. I'm
Just
gonna close.
Sorry, one last thing. In the, let's see, it's 2A and 2B. It seems to leave out the emotional impact. There's the, does it mess with your learning? Does it, are you denied services? And not just, you know, the impact on you as a person of display of hate speech. So, and I just want to note that, and if it makes sense to respond to that, and if you may have had good reasons for just leaving it at 1 and 2 there, or A and B, or whatever the nomenclature is.
Work on that language.
Mary, can you also send around the actual link of the database?
Yes.
I couldn't find it online.
Will do.
Okay. All right. Can we move on? Okay. So we have 2 other policies on the agenda, and I'm going to make an executive decision to postpone the discussion of the Title IX policy changes. And it's not just because we're running out of time. So the Leanne, who is the Title IX coordinator and has been working with Mary on the revisions, and remember, these are revisions that are responsive to both state law and federal law, and it's taking, since they're vastly different in a number of ways, kind of blending the two is taking a fair amount of work. She is not able to be here today, and she has been overwhelmed with some other stuff, so she hasn't quite finished making the changes. So it sounds like an excuse to postpone discussion of this policy until next time, because I want to at least start talking a bit about indemnification. This would be a new policy that is intended to be responsive to some situations that have emerged in the last couple of years. So we don't have draft language, but we wanted to have kind of a conceptual discussion about this, and I think who's going to walk us through some thoughts on this? Liz, is this you?
Yes, I think I can kick it off. I had 2 separate inquiries, one from Rita and one from Julia this summer, about those situations when being an employee of PPS subjects an employee to certain expenses, particularly some licensure challenges that are that can emerge in a number of contexts. Speaking about the legal department, I can say that their is a pretty long history of some complaints being made by people who are unhappy with the position that a district lawyer has taken and then filed bar complaints. We see it in the special ed arena quite a bit, frankly. And I say quite a bit. It's not an epidemic. That's an example. There could be others. And so that is not covered by our by the Tort Claims Act, because it's not a tort, but it can be a very significant expense to a district employee. And so at a very in response to the inquiries from Rita and Julia about that, I looked for some sample policies and other examples, and there are a few, there aren't a lot. Sometimes they're focused on lawyers, sometimes they're focused on a broader situation. But I think, I mean, I'm sensitive to that. As not being an employee, it's easy for me to talk about that because this policy wouldn't benefit me. But I do want to get conceptual direction. The inquiry came from board members about how, you know, how does this work and what do we have and how do we, how are we thinking about expenses? And I'm not talking, I think the inquiry is not related to unethical conduct that is substantiated. It's when some of those processes get used because people aren't happy about decisions. Again, I think there are some examples in the special ed arena that are most poignant, but we can come up with others. So again, I think the idea of how can staff be helpful in providing more information to further the discussion, but this, again, from the board initiated inquiry, I would be helpful and also follow your lead. That's what I would say.
We don't have a draft yet though, do we?
No, I don't. No, we don't have a draft. I don't feel like, I didn't feel like we had sufficient direction in order to produce one. And so that's even just a working draft. We need some direct, I guess what I want to say is we need some direction.
Of what you'd like to see, and then we can put something together. I think for you, but what we wanted to get, since it's coming from you, or the request was coming from you, what we were interested in, where you want us to go with this, what are the specifics you had in mind, or would you like us to present you with, we have a number of different examples. What would be helpful?
So let me ask you this question. Do you have specific questions to which you would like answers? That might be a more efficient way to approach this.
So some of the most, the examples we're most familiar with are about lawyers and bar complaints. But do you want us to look beyond that? We found the City of Salem policy, if I'm remembering, is just about lawyers, because this then happens other places too. This is not unique to PPS.
So I will say my response to that is yes, I think we probably should go beyond attorneys, because one of the things that prompted my question was a comment from a non-attorney employee who was facing, I think it was a potential ethics complaint. I'm not exactly sure. I can't remember. This was a year ago. I can't exactly remember the details, but it was definitely not an attorney. But it was a kind of credible possibility that they would have to be shelling out substantial legal fees to defend against what appeared to be, what sounded to me like abusive conduct.
So would you like it to be something that's done at the end of the process after an outcome? I don't know how else you know if it's right. If there's a finding of unethical conduct, then that may not be something the district wants to defend. So it's an application it's a request to be reimbursed, is the decision maker the superintendent? How do we, I mean, we can come up with some criteria for you to think about, but those are some of the structural questions I would put as we're trying to frame enough for you to react to.
I guess so the indemnification does what? Because my understanding was more in a legal sense, because I'm thinking about there's all sorts of things that happen all the time in the district in which people have to go get lawyers or may want a lawyer, or the district to pay their expenses or to be able to get something outside. I mean, generally my sense was if there's something that happens in the course of your duties and it becomes a legal issue, the district defends you. And I thought my understanding was this is a narrower, this is like in the course of a lawyer defending the district or engaged in the legal process on behalf of the district, which is a little bit different than other cases.
It can be, this is part of the discussion to figure out what do you want the scope of this to be? And if it would be helpful, we could bring some examples with, this is where this might play out. I mean, again, we have not put pen to paper because we really needed some input and direction or just some thought partnership to get the ball rolling. I think maybe it would be helpful if we, again, drawing from other examples from other jurisdictions, what might this look like and what types of things would be in and out, right? And then you guys could adjust that in and out line as you potentially saw fit. You might want to put a cap on it. You know, it might be indemnification up to a certain dollar amount. I think it'll take multiple rounds of thinking through what it might look like. But I think we want to keep our eye on the North Star of what's the problem you're trying to solve, right? And I think what you're trying to solve is when complaints are made against a PPS employee who's acting in the course and scope, appropriately within the course and scope, and has to individually defend an administrative proceeding that's outside the Tort Claims Act, you want an individual employee to not bear at least all of that burden on an individual basis. I think that was the basis for the first inquiry, but the devil's in the details, right?
Yeah.
Yeah, so it'd be useful to know in what cases does the district not provide legal support for staff and say like, hey, you're on your own, or that's separate. So to me, that would be like, in what cases are there? Because my understanding is generally at least at the central office, when a decision is made and there's some sort of complaint filed, that the district defends them, and it's not the person paying their own lawyer.
So when you talk about a court case or a tort claim, right? So there's a statute, and then our policy that repeats the statute requires the district to defend employees who are acting in the course and scope when there's an allegation of wrongdoing in a legal claim. The administrative agency, and again, I think the best example, it comes up in individual licensing, although the Ethics Commission Rita raised from another PPS employee last year is another example where I don't think there is an ability for the district to pay if it wanted to. So another thing you could do is say, you know, the board authorizes the superintendent to have discretion to do that. But right now, I don't think there's legal basis to do anything but cover things within the Tort Claims Act. So if it's outside that, there isn't authority given from the board to the superintendent to pick up any of those costs that an employee is carrying simply by virtue of doing their job for the district. That's the dilemma.
So I think, based on what you said, I mean, a couple of things leapt out at me. I think some kind of monetary cap makes sense. where the threshold is, I have no idea. But, you know, I don't want people racking up legal expenses, you know, on our dime, unnecessarily. What else was I going to say? I would like some ability for the district to deny a request if there seems to be evidence that the person in question was in fact not acting appropriately. I wouldn't want it to be a kind of ironclad, whatever you do, we got you covered.
I don't think you should. I mean, you can't, and you don't want to, and you don't, to the extent the district is the complaining party to an entity, then you don't.
Right.
Right. And there could be a point where the district files a complaint against an employee or a former employee. Like you would definitely not want that, right? Or if you're a mandatory reporter and you have to file that, right? I mean, we would want to think through what all those pieces look like. But
so it seems to me that, I mean, I don't know how many instances we have occurred in the last 5 years. I have no idea. It's probably more than one. It's almost certainly more than one. Is it more than 10? No clue. But I'm imagining that you might need to you know, you might need to make some scenarios up.
I think that would be helpful. Yeah, I think that would be helpful to make sure, because you're trying to stop, you want to solve the problem, but not create unintended consequences and not create an open, I mean, again, I don't think there's unless it has a wildly broad scope that no one's considering, I don't think this is significantly expensive. I mean, the volume is not so high for the district, but it is a significant piece for the district and attracting some people to certain roles knowing that this exposure exists.
Yeah.
So I think from my standpoint, I'm interested in a narrower version and having some sideboards that don't create the impression, the appearance that it's sort of like, hey, if we like you, well, this is covered or not, but that there's some sort of objective criteria that reasonable people would agree on that unlocks that. And I'm with Rita on a cap too, because no cap, you know, it's, I mean, again, the district can always wait, you know, you can make a decision to waive the cap if there's some extraordinary circumstance, but I think having a cap creates a more like, let's try and get this resolved in a way that's not taking money from the classroom unnecessarily.
Yeah, and different levels. I mean, we can bring some examples that we have with former employees to illustrate scenarios. And where you would want to reasonably cut that off. I think most don't go to crazy lengths, but we have one that did. So
I'm of two minds in the idea of reimbursement, because, you know, on the one hand, yeah, it would be nice to have an outcome so that you can be certain that the person was acting appropriately. On the other hand, for an awful lot of people, for most people, you know, covering upfront costs for legal fees could wreak havoc with their life. And I mean, I would be hard pressed if I needed an attorney. So that's a tricky one for me.
Let's continue to think about it, look at some other examples from other jurisdictions and see how it's handled. But I think that's exactly the trade-off.
Yeah. Okay, any other questions on indemnification? Okay, because if we want to do...
Outside my wheelhouse.
Mine too, but I do worry about lawsuits. Okay, we have 4 minutes until 6:50. So let me ask Kara, the people who signed up for public comments, are they already on?
Yes, we now have everybody signed up online.
Okay. Okay, so rather than just waste the next 3 minutes until we're at a time certain, let's go ahead.
Okay. Let's start with Xander Zip.
I love this way is how this is working because I'm seeing Craig labeled as Xander Zip.
Hello. Hi, Xander. You ready?
Yeah, sorry, my Wi-Fi was not working for a minute there, but I'm here now.
Totally understand.
All right. So am I ready to go?
Yes, go ahead.
Yes.
All right. Hi, my name is Xander Zip. I use he, him pronouns. I'm a Madison student, and I'm here on behalf of Publius Students United. None of us are oblivious to the anti-hate speech influx across PPS. Our group was formed in response to these incidents and the need for change in PPS response. We formed a coalition of students across nearly all PPS high schools in order to change the hate speech policy. We are here to propose a partnership with the policy committee so that both admin and students can have a hand in drafting the document designed to support us. The instances that drew the most attention of our group were the symbols on JSU posters at Cleveland, an article at Lincoln, excuse me, and an article at Lincoln. It is important to note that these are but a small fraction of the events that have spread throughout PPS, and also that our focus is on the response to these instances, not the instances themselves, nor the consequences. As the article from Lincoln was what brought our group together, I'll start by talking about it. A student at Lincoln wrote an article in support of the Proud Boys, despite their labeling as extremists. We take issue when a school paper publishes that article as the group is presently inciting violence throughout the city. Lincoln then provided no response to affected students and went radio silent until an issue arose regarding the same incident at a PTA meeting. They then attempted to use restorative justice practices, but did not bring in a coordinator and still made no attempt to support their students of color or involve anyone but the publisher of the article in the RJ process. At Cleveland, the Jewish Student Union returned to school to find a plethora of swastikas and other anti-Semitic hate speech on their posters put up throughout the school. The school took down the posters completely instead of addressing it. What we miss here is the response condemning this action and presenting its affected students with swift support. We feel as though the current policy does not go far enough to support affected students, nor does it seem to do a good job of clearly addressing the issue itself. We as students have a right to a safe and accepting learning environment. Until the current hate speech response is altered, this cannot be achieved in PPS.
Okay, thank you.
Cool. Thank you, Xander. We have Kylie Jones.
Hi. Hello. My name is Kylie Jones. I use she, her pronouns. I racially identify as Asian. I'm a Lincoln senior, and I'm also here on behalf of Publius Students United. As previously mentioned, Publius Students United is a student advocacy group dedicated to creating safer spaces for students of color and students with marginalized identities within Portland Public Schools. We plan to do this by tackling both the preventative and responsive side of hate speech by doing the following: determining where the student, teacher, staff, admin, and board gap is and bringing bridging the disconnect between the two, creating clear and concise definitions of what hate incidents and hate crimes are, redesigning the current hate incident and hate crime reporting system, developing methods to prevent these incidents within Portland Public Schools, whether that be education on various issues within and intersectionality within equity or systems of oppressions or just other forms of preventative measures, and creating support systems for students, teachers, and staff when these incidents do occur. We want to be involved in helping implement the policies within this All Students Belong legislation, and we believe we are uniquely qualified to help implement these policies into the districts. We as students are arguably the most affected group by these incidents and policies, and we believe that in order to best gauge how these policies can be practiced, having one of the groups of people that are affected is extremely vital. If we are able to work with the board and the policy committee to implement the various policies within the All Students Belong legislation, we would lend our perspectives as students who have dealt with these types of issues and types of hate speech within our schools. We would be able to elaborate on the various emotional, mental, and physical effects hate speech incidents have on students and the school community, and we'd also be able to elaborate on how historically where the district has done well in response to hate speech incidents and where it has fallen short. These qualities would allow us to help, advise, and create better solutions to tackle these types of incidents. While all of us may have different titles and roles within the school system, we all want the same thing: safer spaces for students in schools. Thank you.
Thank you.
Unmute. There we go. We have Beth Kavanaugh.
Can I just say while we're waiting for Beth, I was just going to say, can we, the students who asked to participate, if we make sure that Kara gets your email addresses when we go through the next turn of the policy, we can reach out and engage with you all.
Director Brim-Edwards, I do have them, and they should be in board book under when you log in under supplemental resources.
Awesome.
Hi, I'm Beth Kavanaugh. I use she, her pronouns. My name is spelled BETHCAVANAUGH. Over the past year, I've been part of a group of parents and teachers from across PPS that was formed to review PPS data related to foundation fundraising in our district. Members of our group have worked at or have children who have attended schools across the district, including Alameda, Abernathy, Beach, Laurelhurst, Atkinson, Grout, Hosford, Ockley Green, Scott, Roseway Heights, and Roosevelt. Many of us have been actively involved at one time or another in our schools' foundations. In reviewing the district's data, we have found that even when accounting for grants from the PPS Parent Fund, foundation dollars disproportionately benefit students in schools that are predominantly white. I'm here tonight to let the committee know that we're prepared and excited to share our findings in order to bring transparency to the PPS Foundation system and build community support to reform our foundation policies so that they are truly equity-centered. Our research will be released to the public this Wednesday morning through a large network of parents, teachers, and students that told us they want to help inform their communities about the district's racially inequitable foundation policy. This policy committee has an opportunity to be the committee that chose to establish foundation fundraising policies centered on racial equity. My fellow advocates and I look forward to supporting you in that endeavor. Thank you.
Can I just mention sort of point of information?
Sure.
We have the foundation policy scheduled for January.
Right. Yes.
Now. So
thank you.
Just FYI.
That concludes who we have signed up for public comment today.
Okay. Thank you. Okay, we have 5 minutes. Anything else you feel compelled to discuss in the 5 minutes?
Rita, of the very beginning when we talked about different policies that board members would work on, one of the ones that we didn't discuss was the foundation, and I'd like to participate in that.
Okay.
If I may?
As would I, Rita.
Okay.
I want to thank our students who are here today, especially Jillian and Jackson, who are the policy committee students. I know that this is not easy sometimes to jump in on the computer and online and to speak up when we're all, discussing things. So I really appreciate you being here and Parker for coming and adding in as well. And just really appreciate your student perspective, as well as all the people who gave testimony today. Thank you for your time and for your investment in the district.
Yep, what Ailey said. So I'm going to
Wait,
promise.
Rita, can that just be your response to everything? Yes, what Ailey said?
I only do it when appropriate. So
that was it.
That was it. Yes. So I promised to send out an email with the list of policies and committee members attached. It's going to go also to students, and students, let me know if there's a policy area that you're especially interested in working on. Okay? Okay, we're at 6:57. Anything else?
I'm sure there's some minutiae we can talk about for the next 3 minutes and really drag this out. But
I think we should go back to redlining. I would like to discuss some grammatical issues that have emerged. And, okay, just joking.
I think you should have stopped before you said you wanted to go back to redlining.
Okay, all right. If nothing else, thank you all for, it's been a long 3 hours, I know. Thank you for everybody's attention. I think we made some progress. And we will see you back here in 3 weeks. Okay, thank you.